first thank you for coming and taking time out of your day. I know everybody's busy and we all have a lot of demands, but I appreciate you spending some time with me and what we'll talk about. A little bit more about Offutt Kerman. We're 185 lawyers. We have offices, as Margie said, from New York down to Northern Virginia and in Washington, D.C. We have expertise in most areas that you need legal expertise in. There's a few places and securities that we don't have lawyers yet in that area, but commercial litigation, business transactions, intellectual property, real estate, family law, trust and estates, we run the gamut. The firm is really focused on a subset of companies and individuals that have legal needs. It's emerging companies up to mid-market businesses, whether they're privately held or even publicly held. We also represent a number of financial institutions, whether they're venture capital funds or private equity. So that's been our focus. It's an intentional focus on those types of companies, and they've been able to grow in large respects. So as Margie said, it is a fast-growing firm. In 2000, I think we had 15 lawyers. We now have 185, so that's pretty dramatic in the legal industry. So let's get started a bit. This is the first of three parts, and I'll just telegraph a bit where we're going to go. They do build on each other. Today is really a crash course in intellectual property. At the end, we'll do a case study. We'll look at a fact scenario and just kind of overlay some of the things that I'll go over today. And then tease some of the things that we'll go over in part 2 and 3. Part 2 is about IP ownership and what you need to have access to the IP rights to further your business goals, so to speak. So we'll talk about how do you get to own IP? How do you get to license IP? What do you do with it? The last one is in IP and transactions. Think of transactions in a very broad sense. You've got vendor relationships, you've got customers, but we're also going to talk about the importance of IP in securing investment. What happens when the strategic partner comes and you have a mammoth due diligence request? Okay, so we'll look at that in a broad sense, probably go through some more stories, but they build. And at the end of this, I'd like for you to be able to maybe loosely define what your IP strategy is or should be for your own business. Certainly, lawyers and patent lawyers like myself love to help develop that with you, but I can tell you having clients that are knowledgeable on IP, that understand their business and understand how you can use this system is really helpful from my perspective. So as you're going through this, think about the problems that you're facing. Think about your business. Write some questions down for later. Let it just sort of sink in, but you want to take from this something practical and something useful. Okay, so we'll get started. This is a little bit of a continuation of that introduction. What is intellectual property? What specifically do we mean by IP, and how is it used? Those are really the two questions that either indirectly I get from clients. What is it? How do we protect this, and how am I going to use this in the future? And we'll get to all of those. But before let's just talk about what is IP. There's a legal definition, and we're going to spend a lot of time talking about what is IP and what makes up IP. But I also like to think of it as a business definition, and this is mine. This is my own personal view of what maybe a non-legal definition of intellectual property would be. So, creative efforts that give rise to or secure a competitive advantage. The competitive advantage piece is really important for you to think about. If you're looking at your products and your markets, what is it that makes you unique and makes it difficult for your competitors to compete with you? Okay, IP in the legal sense should help protect that competitive advantage. It should support that. So there's this, I say, a loose business definition of IP. Creative efforts. That's what you're doing, the problems that you're solving. If you're designing a new product, if you're designing ergonomics in something, if you're writing code, if you're building a new marketing channel or a new marketing plan, all those are creative efforts, and IP should protect all of those endeavors in one way or the other. The lawyer's job and my job as patent counsel is to take these legal definitions of what IP is and help you put IP around that competitive advantage. Sometimes I don't know what that is. You as the business developers and the business owners are in a better position to really see what that competitive advantage is. Sometimes maybe you're figuring that out, and that's okay. But think about this as we go through the trilogy, as we just learn about IP together. What are your competitive advantages? A couple of general comments about intellectual property rights, and this is really important to understand. They're really negative rights, okay? They're exclusionary rights, and the best example I can say is, let's say I own a plot of land and I put a fence around it. Nobody can come into my plot of land on the other side of the fence without my permission. Okay, my ownership in that land is exclusionary in nature. I have the right to permit who comes and goes. But because I have my own plot of land, doesn't necessarily mean I can go into somebody else's. Okay, so think about it this way. Let me bring this out of an analogy and say it maybe more precise from a legal standpoint. The fact that you own IP doesn't necessarily give you a right to make, use, and sell something without potential risk, okay? It's two issues, separate issues. What you do to protect your IP, and then what you need to do to maybe avoid a third party's IP. That's only an issue because IP rights are exclusionary. Right? They only prevent people from doing things. And if somebody does, say, come onto my plot of land, the law gives me the right to sue for damages. This is generally the approach that's available in intellectual property as well. They're territorial, meaning there is no world patent, there is no world copyright, there is no world trademarks. There's U.S. rights, there's U.S. trademarks, there's Canadian trademarks, there's Canadian patents. You know, all of these different protections are really geographically limited. There's some outliers and some exceptions to that. We'll get into a little bit of those today. But keep in mind, if you want, there is no worldwide patent. I get that question a lot. Well, how do you protect patents outside of the U.S.? We'll touch on that a little bit, but they're territorially limited. Okay. So the big components of intellectual property are these three rights: trademarks, copyrights, patents, trade secrets. To some extent, there are some contract rights that may protect IP, okay, in some sense. But by and large, if I'm analyzing a product or a service, I'm really trying to fit what you're doing, what the product or service, into one of these categories. And how do we go about doing that? We're going to go through all of these in some depth. So trademarks, let's get everything up there. Trademark rights, it's really a source identification. It's not about the functionality of the goods, it's not about the technical details of the goods or service. It is a source identification. Trademark, this is your brand. I mean, these are the brands that we all know and can appreciate. But trademark rights are designed to protect that emotional connection that a consumer has with the brand. Okay. All about the source identification. So the Apple sign, Apple, the Coke bottle is actually a trade dress, a type of trademark. Dell, logos, words, symbols, things that identify the source. Okay. Now, what about, what makes a strong trademark versus a weak trademark? Well, if you do any Google searching on trademark strength, you'll get this strength strict spectrum. On one end, you have very generic, descriptive words, very weak trademark protection. So I'm not entitled to a trademark that just says legal services. It's completely descriptive of what I provide. All right. I may have trademark protection to something a bit more arbitrary or fanciful, peregrine. Peregrine identified as legal services. That word has really nothing to do with legal services, but it could establish a connection between the consumer and the services that I provide. Okay. Now, if you think about this, we're talking about your brands. You don't necessarily want to be, you want to be unique in that, in some respects. Okay. It might be nice to have trademark protection in legal services, but the law recognizes that that would limit the ability for other legal service providers to communicate, frankly. So we don't give protection to very generic or descriptive words or phrases. We do give protection to something that's a bit more arbitrary and fanciful. Nike, it's not necessarily descriptive of any particular good or service. It's descriptive of it. The other piece of trademarks is the law doesn't want confusion in the marketplace. So one trademark shouldn't be confusingly similar to another trademark because, well, that would be very difficult for the consumers to identify. Okay, well, how do I know this good or services is the quality and the type that I'm accustomed to? So you can't have trademarks that are confusingly similar to each other. What types of trademarks? And you've seen this, I'm sure. There's the TM as a superscript or the R in a circle. It just identifies different types of rights. There's common law trademark rights. Trademark law arises in the United States by use in commerce. You use a brand associated with some good or services that you're offering in exchange for revenue. That's a use in commerce. It just arises through that use. At that point, you're not necessarily required to file for a trademark application or a registration. You just have those rights available to you. You can, if you elect to, file for a trademark registration with the U.S. Patent Office. If that is approved, then you, of course, get to put the R in the circle next to your logo and your trademark. Okay, two different rights cover the exact same thing, really, but their remedies are a little bit different, and there's some additional protections that you have with registration. One thing that's important to know, especially if your business is a bit service-oriented and geographically focused, your common law rights are only extend to that geographic range of which you're operating. Okay, but what if you file a trademark application with the U.S. Patent Office and it gets approved? You have a presumption of nationwide rights. Okay, so it's an important distinction. There is certainly value here, but keep in mind your rights do arise by using it in commerce. The registration isn't going to necessarily.
Are you taking questions?
Yeah, please.
What if you're selling online with a TM and you're not necessarily selling within a regional area, but you're online and you're selling throughout the whole U.S. or world?
That's a good question. So trademark law does account for that. If you've got use in commerce, I would say, publishing online, in addition to evidence that we've sold and shipped products to places all over the United States, that's a really good case that you have widespread trademark protection. Okay, now think about how that issue would really come to play. When would that matter? It would matter when there's a third party that is using your trademark or something that's close, and there'd be some contention there. All right, and in that context, there is you don't lose anything by going ahead and filing for the trademark registration, because that's sort of an additional arrow in the context. But I think your question is good. It's coupled publication of offering the goods or services on the web, but coupled with some evidence that you're actually shipping it to all 50 states. That's a stronger position, I think. Yeah. Any others before we go there? Go further? No? Okay. selecting a trademark. And some of the things, what we've talked about is to help guide that, but I recommend, and not every client will do it, but I do recommend once you have a trademark that you've identified that you do a clearance search. Right, now what does the clearance search do? It's really to help you understand, one, is your trademark or your mark or your logo, is it registerable with the United States Patent and Trademark Office? Would you be entitled one day to put the R in a circle next to your logo? All right, can you do that? And the other is to identify potential risk of third-party marks that may be out there. So let me just say a little bit about the trademark application process. We identify the mark, you identify a goods or services, you file it, this application with the U.S. Patent and Trademark Office. Eventually, an attorney will examine it, and they will do a search of various databases to see if there's something out there that looks confusingly similar to the mark that you applied for. So doing a search beforehand is just staying a step ahead of what the Patent Office is going to do once you register. And we can react to that a little bit better, or position the trademark application so that we avoid some hiccups that may come. The other part of the search, and from my perspective is much more important, is there another mark out there that the owner of which would be upset if you started using it? Okay. You want to know if you're going to get a cease and desist letter when you have success. You may not be an issue now, but usually success brings, additional casualties of success, and that could be somebody's upset about using your particular mark in a certain way. If I put Nike IP Legal Services up on our website, I guarantee that Nike will send me a cease and desist letter because they're monitoring it. They don't want anybody to encroach on that particular right.
But if you use Greek letters.
Greek letters, it's a good question.
Nike was a goddess.
Yeah, it was a goddess. You could use, I think they would take issue with that. Nike, it's a famous mark, and famous marks have some additional protections. Okay, but let's take Nike out of the question, and can you get a trademark on Greek letters, maybe applied to a specific good or services? Maybe, but what if that string of Greek letters is very descriptive of the good or service? That's a closer call, I think. That's a closer call. Yep.
You talked about databases during a database search.
Yes.
There's a trademark database that you can search online.
Yes.
Are there multiple? Are there others?
Well, they're commercial databases that will compile information from state trademark registrations. There is a database available directly on the USPTO's website that is certainly searched, but the examiners will search broader. Their databases will have broader access than just that. So you're looking for marks that are out there in commerce. And so you want to know, maybe there's a common law right in California that is just being advertised in a particular way. Can we uncover that? We have a number of clients that are in the music business, and band names is, if a local band in Philly wants to trademark their name, well, that might be fine. They may not have an issue in Philadelphia, but maybe there's somebody in Chicago that has a similar name. And then you get to who's doing it first. You may not find that just by doing the USPTO search. It's a great first step, and if before you talk to any attorney about trademark, if you can get to that website and do it, check it. And if there's hits, then you got to do a little bit more digging and sort of wade through that.
There are other state databases that are...
You can register a business. Well, let me take a step back and make sure. I've said brands, and trademark does protect brands, but it's also your company name. All right, and so there's databases for company names at every Secretary of State in the United States. So some of those names may be relevant depending on how they're used in the marketplace. So those are some. When we do these, yep.
Oh, you can finish.
No, I was saying when we do the search, we hire a third-party search firm who specializes in trademark searches. They do a number of databases, Google searching, they check the PTO databases and a number of other places, and then give us a very thick report in 3 to 5 days. And they're just very efficient at it, and the cost is pretty reasonable to do that.
So like 2 questions. Number one, if you want to do like a rebrand of your logo, is that covered, or do you have to do that every time you do totally new?
Yeah, so I'm going to put the answer on a spectrum, all right? I think if you're doing a rebrand, what I call conducting a knockout search, which would be accessing the PTO database, just to see if there's something there, you certainly should do that. And if you have a series of names that you're interested in, maybe you whittle it down to 2 or 3, and then you do this clearance search right before you're ready to pick. So I don't think you need to do clearance searches for 5 different brands if you're only going to pick 1. If you're only going to pick 2, you can whittle it down. But a low risk position is to do a clearance search on every brand that you're going to put on anything in your products and services. So.
And my second question is, if you, let's say you wanted to make a logo that organically generates itself, so it's constantly different every second.
Gosh.
Can you cover that?
That is really interesting. Let me tell you what I know that can be. So words, logos, scent, color, sound, slogans. Okay. So sound kind of fits in this category. It's not necessarily changing, but it does change. It has a temporal, limitation. I'll have to get back to you on a self-replicating and changing, trademark. It presents an interesting question. It's interesting and challenging because your trademark rights and your strength is largely based on your consistent use of that trademark over time. If you're using it consistently over time, you're enforcing it consistently over time, trademark rights practically gives you some added protection and some strength. So it does, the idea that a trademark changes, it does go against some maxims in trademark law. That is a little, no, it's
Would
okay.
it depend on how you trademark, and so if you describe it as it is a logo that constantly changes every blah, blah, blah.
That's right.
And this is the name of my business and blah, 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 if you describe it correctly, then yeah, you could protect
Yep.
that, but you're protecting the fact that it changes all the time.
Yeah.
You're not protecting each individual.
That's right.
Okay.
I think that's right. The only thing I would add to that is the only time you really have a right to, not a right, but an instance to describe that is really in your trademark application that you file with the U.S. Patent Office. Okay, and you may address some of the issues that I've done by that, but that doesn't mean there isn't some common law right that's out here, if you're using it the same way. So, interesting question. Yes.
So your logo's up there. Let's say you did a rebrand. You use the same text, but you changed your font and colors and all that. What happened if I went and took the same layout of your old logo that you no longer use and maybe you haven't used in a year and put my information on that so it appeared very similar?
Well, there's 2 ways I would attack that. Number one, are you using the same word? Because in a word mark, you're just protecting the word itself. So Offutt Kerman, we have a registration for that. It's not necessarily limited to the blue and the line in the middle and the font. It's just the word Offutt Kerman. So if you use it in some way that's confusingly similar, and now you want to offer legal services, because that's likely what our goods are limited to, then I'd have a basis to send you a cease and desist letter. Now,
So
let's
you
say you
protect
change
the
the,
text.
let's say I have a logo that's just as you see, but you change the words, but it looks a lot like Offutt Kerman somehow. I don't know how you would do that, but let's say you can. I would still have a right on the logo side of protection. Okay, so it's a good distinction to appreciate.
So the logo would protect, because you see what I'm saying? Someone
Yeah.
can come out with the same font and everything, same
Yeah.
color, after you stop using it. Are you no longer protected after you stop using the old logo if you
Well, there's two issues in the question. Stop using, you lose trademark rights, okay? Because our trademark rights are based on use in commerce. Once you stop using it, you lose the rights. And if you don't have rights, you don't have a way to enforce them. Okay. If we abandon off at Kerman and the blue and the line, we wouldn't have any basis to come after you, in the future. Because
So if you did rebrand, then I could come in behind you and create something similar and possibly be.
you could, if we stopped using our rights and stopped enforcing them. So there's registration that you would lose. And every 5 and 10 years, you have to submit a declaration to the U.S. Patent Office saying that I'm using this in commerce and here's some specimens of use. So there is some ongoing obligation to communicate with the Patent Office to affirm this use. Now, what sometimes happens is we may, if you're inaccurate in those declarations or false in those declarations, if you try to enforce that in court later, that's a basis to deem your trademark rights invalid. So there is a backstop against fraud, I would say, in that regard.
Also, how accurately can you search for sound and scent?
Not very. I mean, it's hard.
So you could very realistically infringe on a small company that becomes successful later, and if they have an earlier date, then that will be a legal issue.
Yes.
Okay.
Yeah. It's hard to know what sounds are protected. The NBC sound, that's one. Dell. Yeah. But those are pretty famous marks, and you have to have some use, and you have to have an association with the mark. Has an association with the goods or services, and has to be really recognized as something that's worthy of protection in that regard. So I can make a sound and file a registration for it. Doesn't necessarily mean I'm going to get it, because I'm Greg and my sound is. They're like, so what? But NBC, who knows it, the insulation, Owens Corning, pink, they have a trademark to the color. That kind of makes sense to me. I mean, their pink insulation is everywhere for the most part. So, did someone else have a question? I saw a hand. Yeah.
There's a group in New York now called Audio Brain, and they're actually developing the sounds for companies, branding sounds, and
Okay.
they are going through the process of digitizing them
Got it.
for the records. So
Yep.
they're also dealing with the IP on the other hand,
It's
including
interesting.
like when you walk on stage, a CEO walks on stage in that 10 seconds. Snippet.
Yes.
So they're now working on that, and they're becoming very well known. Other companies are starting to follow, but
Yep. That's
they realize that there's a niche opportunity.
That's a good comment, and it leads into copyrights, I think, nicely.
Yep.
So this is the next right. Copyrights, I think, are interesting. They're fascinating to me. This is the legal definition you can see up here. Works of authorship fixed in a tangible medium of expression. Okay. If I decide to put draw something up here, the act of drawing it on the wall creates a copyright in me. I own that copyright to whatever design I apply to this wall, whether or not I own the wall or not. Okay. It's created at the moment the work is fixed. And here's a list of examples you can see here, but this is pretty broad. Okay, it could be songs, it could be music, it's the content of your web page, it's what people see when they log onto your website, it's code, it's user interface if you have an app, anything that is an expression of some creative effort. Okay, some parts of the underlying code are subject to copyright protection and are available. So the remedies and rights that go along with that are available in software. That's a more important, or I say a growing area of importance for software in the than patents, for a number of reasons we'll get into a bit. We'll explore the implications of what this slide says a lot in our next IP seminar. But I want to just raise it. The individual authors own the copyright. In my example, I put a drawing up here. I'm the owner of that copyright. If I never come back here again, I still own the copyright. Okay. Works created by employees within the scope of their employment are owned by the employer. Independent contractors, on the other hand, own their copyrights unless there is a very specific writing to the contrary. Okay. You can't you can't hire an independent contractor and issue a 1099 and own their copyrights unless it's in writing. So transfer of rights must be in writing. So this is an area where we get lots of questions on. This is a big focus on due diligence investigations that I do. Do we have the right assignment documentation in place to make sure the company owns the IP? For certain businesses, it's not as important, but if you're a software company, this is critical, really. It's really important to have that squared away. Some of the rights that reproduction, you can reproduce it, copy it, really, distribute it, performance or display, create derivative copies of the work, conduct digital performance. Create derivatives. In the software context, you can kind of see where this will go. I develop an app, I develop the back end and the front end and the mobile side. I did it all in-house, but let's say I hire a third-party software development company to help me with it. Well, technically, they're making derivatives of my own copyrighted work. And your agreements need to account for that possibility. So something to think about, derivations of copyright work. In law school, we get the examples of if I have the owner of the Mickey Mouse copyright, Disney. Right? That character is subject to copyright, but a derivative work, of course, is the cartoon, a movie, games. You can see where this can expand. This idea of derivative works, it is really the underpinning of our media industry, okay, and how these stories come from books to theater is a lot based on derivative rights and original copyrights. Yep.
So, is there a separate copyright for each instance of Mickey, or is it just,
Yes,
Yeah.
it is. So you have a derivative right for Mickey in the movie, but that movie itself also has its own separate copyright protection.
Right.
So think about that a bit. It takes more than one person to make Mickey in the movie. So the creative people involved in that are really co-owners in that. Now, if you think about that, then the agreements of everybody that's involved in Mickey the movie is really, really important. Let's see, infringement. So this occurs when one has violated one of those exclusive rights. So if somebody reproduces or distributes a right, if somebody makes a derivative of your copyright, that's a copyright violation, and you have basis to file suit. One thing I'll just mention, I didn't put it up here or in the slides. Copyright, your rights arise at creation. There is a step you need to take if you want to enforce those copyrights in court. You have to file it with the Copyright Office. It's pretty straightforward. It costs, I think, $40 to do. But that is one affirmative step you need to take to file suit for copyright infringement. It's not necessary, but it's just you'll need to do it. Injunction, impoundment. Can you imagine that? Your product's being impounded because of copyright infringement? That's a terrible headache to deal with. Actual damages, statutory damages, I think is $150,000 per instance. So each copy that you infringer makes, it's attorney's fees for sometimes. If the behavior is egregious, you can get attorney's fees for copyright infringement. So one thing I'll just mention here, and I'll keep going back to this idea of an exclusionary right. This is what happens if somebody infringes your copyrights, all right? But the converse is true. If you infringe another's copyrights because you haven't cleared it or haven't done the analysis to make sure it's substantially different, then that's a risk that you would incur or potentially incur. Trade secrets. We won't go a lot into this, but there's trade secret protection. Think about that thing which would be terribly harmful to your business if it was known publicly. What would really disrupt your operations and make things difficult for you if it was publicly known? That's the type of information that is subject to trade secrets. A couple of things to keep in mind. It's got to be a secret, okay? It has to be valuable to the business, and you have to take steps to ensure its secrecy, okay? Non-disclosure agreements, limiting access in the lobby, making sure people can't come and go. You have to take reasonable steps to do this. The example that we go through in law school is, I think it was DuPont built a polyester plant back in the 70s, and a competitor purchased a charter plane to go over the plant and to take pictures of it as they were building it. Because if you get a chemical engineer up there and kind of, you know what capacity is, you know what the inputs will be, well, the court said, you know, that's a trade secret. We can't expect DuPont to put a tarp over a, I don't know, 100,000 square foot space. It was larger than that, but that's sort of one way to think about it. It has to be reasonable under the circumstances. If you have a device that in and of itself isn't new, but the way you make it is, you should limit access to that process in a objective way, okay?
Are
Yep.
these rights provided kind of inherently, or is this something that you have to come and get protected?
For trade secrets, there are provided, and I'll say this, I hesitate a bit. The law provides the right to sue based on trade secret misappropriation, okay? There are state rights, and there are very recently federal rights. So if I have, 5 years ago, if you had businesses in California and on the East Coast, you would have to decide, well, do I want to sue for trade secret misappropriation in New York state court or California state court? Now you can file suit in federal court in whatever jurisdiction makes sense. So the rights are really based on the infringement of it, and they set out some boundaries. But there's nothing affirmatively you have to do to have trade secret protection other than ensure that you maintain its secrecy. And once it's gone, once there's no more secret, it's published, there is no trade secret rights.
As far as I'm sorry.
No, go ahead.
As far as the example that you gave, there was no way they could reasonably secure that site,
Yeah,
so then they still had rights.
they still had rights. Okay, and that's a pretty extreme, I think, example, rightly picked in law school settings. But I've seen companies do a couple of things to help secure trademark protection, and this touches on patents as well, because there is a related issue in the patenting context. I've had clients decide we don't want patent protection, we want to maintain this as a trade secret protection, and it's process oriented. We will document that in a way that is kind of like a patent application, and that's just sort of held on file with the company as this documentation in time, this snapshot in time of what this trade secret is. Clearly you limit access to that. That's, 2 or 3 people should probably ever see that. But that's one way to help document it. And if there is some trade secret misappropriation, in this context it would be an employee who left, and you think they're stealing trade secrets and going to start this new process. Well, in court you bring this documentation out. It's witnessed by people that maybe aren't necessarily inherently involved in the creating of the trade secret itself. It's pretty good evidence that you had this trade secret at this time. So
that's usually how they go on their customer list?
yeah.
Because it seems like so hard to prove that
Yeah.
someone took it.
Well, it's a bit nebulous. I mean, I think some of the questions you're wrestling with, where are the boundaries of trade secret law? Well, that's some of the challenge of it. You had a question?
Yeah, one practical question. Usually when you are an employee, you are guaranteeing that keeping the trade secrets and non-disclosure,
Yes.
all these things. But those things expire.
Yes.
Expire 2 years, 4 years, whatever.
Yep.
What about the expiration date? So let's say
That's a
I
good
work
question.
for a company and now I'm advising other companies But I actually still try to avoid all those topics
Yeah.
because I'm not sure whether these dates are really releasing me
Yep.
truly.
Well, that's a good question. So there's two, I'm going to divide it up into two issues. Trade secrets last as long as you can keep them secret, indefinitely. The Coca-Cola formula apparently is known by two people, all right? And they'll have protection for that as long as it's secret. Whether you're complying with your contractual obligations and your employment agreement, it's really a separate point. There's certainly limits about how we can only limit an employee's ability to work. You know, hence there's a time frame, usually for a non-compete or even for confidential information. So, you know, generally the term is the term as set forth in the contract. The underlying trade secret, though, one of the issues one would have employment agreements like that, maybe the trade secrets, but that trade secret right itself is indefinite. Yep.
So, with a trade secret, you're taking a risk, right? Like, let's use
Yep.
Coca-Cola as an example, but say if someone else figured out a way to make Coca-Cola exactly the same way they do, and they patented that rather than making a trade secret, would Coca-Cola then be at risk for them if they could like, chemically prove it?
It's possible, you know.
Even though they've been doing it for years.
Yeah, it's entirely possible. You've touched on a number of issues in patents that we'll get through, and it'll make a little bit more sense. But trade secret also recognize you can't have trade secrets for something that's easily reverse engineered. That's not really a trade secret. You know, if you can derive it independently, that's not a trade secret to that person or individual. So the decision of trade secret versus patenting is how well do you think you can actually keep it a secret is really the question that I advise clients on, this trade secret versus patenting issue. It's not an easy one, to wrestle with. Yep.
Business can be nasty, but if you want to break a trade secret, then actually what is happening, usually you engineer a process to show that you invented on your own.
Yeah.
And it happened that overlaps.
Yeah. So one thing, and this is probably a good time just to go into here is just the misappropriation of trade secrets. These are just the legal actions that you can take. But let's go into patents because it touches on a lot of the issues that you brought up and you in your example. This is where we're going to go through. We're going to do a bit of a deep dive in patents, mainly because I'm a patent attorney and it's generally a little more complex than the other issues that we've talked about. But just to kind of telegraph where we're going to go in the trade secret context, sometimes I will have a client do a search of some concept to see what's in the public domain. Something that's published that isn't subject to a patent right is in the public domain. If it's in the public domain, it cannot be a trade secret because it's already out there. Sometimes where you might have something that really kind of touches up against what is in the public domain and what is out. But one way to know is do a search. Is your secret really a secret? Okay. Overview of patents, basic requirements, obtaining a patent. So patents protect things, they protect functions, structures. I had a supervisor who liked to say, and I like it too, it's technical solutions to technical problems. I mean, that is the essence of what a patent should be protecting, okay? Products, processes, systems, a device, a thing. You can pick it up and it's concrete. But it could be methods, surgical methods. I have a lot of clients in medical devices, and surgical methods are an important form of protection. Back to our exclusionary right theme. Patents, it grants an owner the right to prevent others from making, using, and selling that which you claim in a patent. And this right, importantly, in the trade secret context especially, it's given in exchange for you disclosing to the public how to make and use the invention. as it's claimed. All right, that's the trade-off. So if you have a trade secret or something that you want to protect, but you're worried about your ability to maintain its secrecy, then that counsels towards seeking patent protection for it. Because if it's going to go out anyway, you would want to have some IP rights. Okay. Now, there are ways to sort of navigate that. Maybe we protect one part of the trade secret, but there's some other piece here that's maybe the process oriented that you'll keep as a trade secret. I'm sorry, we protect one part as a patent and another part as a trade secret. That's possible, but it requires the lawyer to really understand all of that, on the outset, and being frank with someone and your counsel is like, look, this is something I think we can really protect as trade secrets. I want to seek a patent on some features of this, but I'm just not willing to approve the patent application with this in it. That's okay. You can proceed in the face of that risk, and we help clients make that call, but there is a tension between trade secrets and patent protection that you want to keep in mind. Types of patents, utilities, these are the most common patents. A utility patent that protects function products. Design patents, I really like working on design patents. I think they're interesting. They protect the ornamental appearance of something. Furniture, consumer products, packaging, really a range of things. User interfaces, screenshots. Apple makes really good use of their design patents. Their fight with Samsung that they recently settled, one of the most important patents was a design patent to the home screen, for the iPhone. So really, really interesting. Plant patents in some cases. Types of patent applications, and these, I'll be very clear about what's a patent and what's a patent application, but utility, provisional, continuation, divisional, design applications. We'll get into each of those a bit. So up on the right, that's a granted U.S. patent. It's the number, U.S. patent number. Publication, that means it's a patent application. It's a filed application, but isn't been approved yet as a patent. All right, so let me get everything up here. I don't know why we did that. These are the basic things that I'm looking at complying with when I'm preparing a patent application and filing with a patent office. The biggest and most important areas are in bold: patentable subject matter, novelty, and non-obvious. We only get protection for inventions that are new and non-obvious to a person of ordinary skill in the art. Okay? New or novelty is really a fairly easy standard to meet. You just have to find one thing that is different from the prior art. It doesn't have to be the essential thing. It doesn't have to be really important. It just has to be one thing. Non-obvious is a bit different. You've got to show that it wouldn't be obvious to somebody looking at what is available before you file the application to combine it in the way that maybe you have. We'll expand on this a bit. Patentable subject matter has really been a recent issue. The law will not let you even apply for patents, theoretically, if you're not patentable subject matter. So the patent law doesn't grant protection for abstract ideas or natural phenomena or natural laws. I can't write a patent to a claim for gravity. It's kind of silly, but that's basically it. Pure algorithms. The metabolism of something in the body, a metabolic function, not eligible for patent protection. Yep.
So how do patents apply to living organisms, like genetically modified organisms?
So there is a number of cases sort of pending, on the issue. The Supreme Court has said you can't have patent protection for DNA. Okay, and DNA even as it's isolated, in its isolated form. All right, pure DNA in its isolated form. That doesn't mean you couldn't file for patent protection for the system that allows you to isolate the DNA. The device itself, or the method of going about that. But the pure organic organism or a human, you can't file patent protection for.
What if you develop that?
Yes, you can.
Yeah.
File a couple of patents on this, that if you make a recombinant protein that does not occur in nature.
Exactly.
In its form, then it's patentable.
That's right.
And same true for genetically modified organisms.
So it's where you would patent the protein in the animal so that, like, it's not patenting the animal, but it's patenting the protein in it, so you couldn't replicate
Yeah.
the same, right, okay.
Yeah. Yep.
So I have like a machine question. So there's a company that made a new technology for 3D printing to make stuff print faster.
Yep.
And so I was asking them a whole bunch of questions, and so I was going through their patent, and they tried to patent any kind of gaseous material going through a substrate, which I thought was really weird because
Yeah.
they only use one for this certain product.
Yep.
So I found it weird. Can you do that?
Yes, there's reasons you would want to do that, and let me just move on, and I'll get into that.
Questions.
Yeah. So these are the three big things that we wrestle with. I put them in bold. This is the issue in developing and securing patents. These questions that you're asking. I put written description and enablement. That is the requirement that we actually disclose what we want claims for. Okay, and enablement. I go through this quite a bit. It's not a patent isn't a manufacturing specification. It just has to disclose the invention in a way that will enable someone to make and use it without undue experimentation. The case that holds that will say that there's a number of factors that go into that. So, but practically, if you picked up the patent application and you look at the claims, how much work would you need to do to make and use it? If it's not an unreasonable amount, the claims are probably enabled. Okay, but you don't have to have a manufacturing deck ready to give to a third party and say, look, you can make 100 million of these with this. That's too much detail. You don't need that. Now let's get to parts of a patent, and I'll get to this. A couple of things. Date of the patent, that's the issue date. After that date is when somebody can sue you for patent infringement, or you can sue somebody for patent infringement. Title, inventors, this date here, the filing date. Everything before that filing date that was published is the prior art. That is what the claims are compared to. Everything before that particular date. Important date. Here, this is also, this is a list of patents that the inventor and the attorneys have filed with the patent office that said these are relevant to the invention. I have an obligation to file everything that I know that is material to the claims. It's an ethical obligation. Inventors have an ethical obligation to do the same. So it's a bit administrative, but failure to cite something that is very relevant to the patent office and you get a patent from it could render the patent unenforceable. So it's a little thing that can cause a lot of trouble. Yep.
So can you sue for something between those dates?
Yep.
Anything like made after your filing date?
You can't.
Before the date of your
Yeah.
patent
So
issue?
you can only get damages and you can only sue for infringement for actions after the date of issuance, which will be the date of the patent, February 5th, 2008. There is very limited rights. They're called provisional rights. If you have a patent publication and you give notice to a third-party infringer and say, here's my patent publication, I think your product infringes these. Once it issues, we're going to sue you. All right? If the claims don't change at all between that period and when it's issued, then you have some provisional rights. But you still can't actually do anything until February 5th.
Oh, yeah, that's what I'm saying.
Yeah.
So like, you can go back and sue people that have made stuff after the 2004 date once it's issued.
No.
Right?
There's only one limited exception for that. So you can't sue for infringement for anything that happened before the date the patent was issued. Yeah.
At the same time, so I only know about trademarks in this way, but the start date of the actual use of the thing, would the person that created that thing before you be able to then go and get a patent and have it backdated to when they started it and then sue you?
It's possible.
Because
No.
that's kind of the way it is in trademark anyway. Like if they can prove that the start date is a date that's earlier
That's right.
than your start date, then they can actually.
There is there's something in patent law related to that. So let's say I invented something and then somebody else later filed a patent for it, and then I would have prior rights in my ability to obtain a patent because I invented first, provided I do a couple of other things. Okay.
You would have to go and then actually create a patent.
Yeah.
And then kick them out of their patent.
Exactly.
Basically.
Yeah. But that's the issue. Really, it's about the validity of the patents, not necessarily infringement of them. All right, two separate things.
Okay.
So, written description of the invention must enable manufacture and use drawings. Here is in the summary of invention. You have to describe the invention. So when I'm drafting a patent application and we've agreed on the claims that we need, this is the scope of protection that we're going to have. I may describe alternatives in the patent application in a certain way because I want the claims to be read broadly. I'll give you an example. If I call a bone plate a bone fixation member, but in the description I describe that bone plate a number of different ways. It's rectangular, it's a rod, it's cylindrical, then in U.S. law, my bone fixation member should be read broad enough to cover all of those different versions or embodiments. Doesn't necessarily mean I'm trying to get coverage for a rod, a rectangular bone fixation member, but I'm trying to support a breadth, the application. We have to describe all those alternatives to the extent we can in the description, but the claims, this is what you pay patent attorneys for, is drafting this thing. It's the numbered sentence at the end. This is pretty long, but it sets forth the metes and bounds of the claim. This is, the case law says the name of the game is the claim. And there is truth in that, all right? This is similar to the fence around my plot of land in the example that I gave you earlier. If you step within that claim, you infringe the patent and you're exposed to patent infringement risk. If you're outside of that claim, you don't. So if and this is an oil and gas tool, a rotor repulsor, let's say I made one, but I don't have a rotor in my device. I don't infringe. I don't have risk. I don't care about this patent. Okay. If I do have a rotor, maybe I don't have something down here. I don't know. But it's the claims that are important. So when you're looking at what a third party is, what are they seeking to patent? The number of sentences at the end is where you should be reading and focusing your attention. Because if it's not there and it's not claimed, they're not going to get a patent for that. The rest of the document just supports what's in the claims in some way or the other. And they should be read. They should be broader. Define scope of the rights, valid claims. We're talking about novelty and non-obvious over the prior art. Okay. We're going to go into, yep.
Can some company claim for a patent where they just want to claim for a concept? It's not proven, they might do it in the future, but it's just a concept and they can explain that concept.
Yep. Well, I would say there's nothing preventing them from filing for patent protection and that patent application becoming a matter of public record, a publication. Now, let's talk about the process, and I think it'll answer some of your question here. So, the filing date, you remember we talked about that on the patent. This is the important date. Everything to the left is prior art, publications, meaning journal articles, web pages, any other published patent application that happens before this filing date is all prior art. In preparing a patent application and filing for patent protection, you have to be novel, new, and something more than that, non-obvious, over everything that's in red. All right, so if Apple, in one example, files a broad concept in a patent application, number one, it's really hard to get very broad claims because there's a lot of prior art out there right now. We're at 10 million patents. That doesn't even include the publications or the other literature that's out there that's available. They may have a very hard time actually getting to this point where the patent is allowed on issuance. Okay, they may not get to that point. What they will do though is generate prior art for third parties because they now have a publication out there. You know? I have some clients who have very focused strategies on filing patents for what they want to commercially protect and don't really do a lot of defensive publications, but there's some that they want prior art out there. They may never commercially implement something, but they will prepare an application just for the purpose so nobody else can claim and file a patent on it. Okay.
What do you mean by prior art? That's not a patent now, right?
No, it could be. It could be a U.S. patent that was filed before this date. It could be a patent application publication.
Because I know like Apple has a patent for a compressed gas system that would be installed in your phone
Yep.
to orient it to the screen that is always up if
Yep.
you drop your phone.
Yeah, that's-
Obviously that doesn't exist.
Yes, but it's still prior art right now. I can't go get a patent with a smartphone with a compressed gas
Well, you
system in
can
it.
manufacture it.
Yeah, if
It is abandoned.
yeah. Well, if it depends on what the claim says, but you know theoretically, you could manufacture it. Patents don't prevent you from manufacturing. It's just a matter of you taking a step and what risk you might see. Okay. Yep.
This kind of goes, I guess, to the next subject of actual enforcement. So, I mean, one of my partners always jokes like it takes 6 figures to get a patent and 7 figures to defend it.
Yeah, I'll show you some statistics that bears that out.
Yeah, so I mean, let's say you're a small company that has these patents and somebody clearly infringes, and they're going to be like, okay, well, sue me, and you know they'll just clean you out. I mean, how does, you know, because I was before we filed something, we were thinking about just doing trade secret.
Yep.
But you know, what's
Okay.
you know, I guess, how do you?
Yep. Let me get to that. I'm running a little bit out of time, and I don't want to keep everybody, you know, past 1:30. But I'll get back to that. There's some statistics there. Just patent prosecution, on average, 2 to 3 years. Sometimes it's greater. Sometimes it's longer than that. If you've worked with patents in the past, the examiner issues an office action. They look at the prior art and say, no, your claims are invalid or are not patentable for X number of reasons. You can file a response. And that can go on indefinitely, really, until you get to that claim that's allowed. Okay. What can void patent rights? What do you do to mess up your patent rights? Well, publish a paper describing the invention. Means a website, offer the invention for sale, okay? Publicly use the invention. In the US, you do have a grace period. You know, we have 1 year after you publish or offer your invention for sale. But the important thing is if foreign rights, you don't have a grace period for. So Canadian patents or European patents, it's an absolute novelty system, and you lose patent rights if you publish it before you. Yep.
Offering for sale, does it include also offering for investor, or presenting it to an investor?
The
Does it void?
not presenting it to an investor isn't necessarily an offering for sale, but it could be a disclosure that would foreclose foreign patent rights. So you have that negotiation or that discussion after you have a confidentiality agreement, which sort of would address that here. 1 year grace period, we've talked about that. I want to get to an example at the end. 2 things I want to make sure we get to before we run out of time. It's just a recap, and we'll send this to Margie. You'll have all of these slides. You can go back. One thing about continuations and divisionals, we'll go through this example. I think it's important for you to understand this. It's a unique thing in U.S. patent law. You file your patent application. Before it issues, you can file a continuation, and you can keep doing this indefinitely. You can file continuations for as long as you need to. If you look at some medical device companies, especially in the orthopedic space, you'll see this long, very long priority chain that goes back 15 years. They will keep an application on file for reasons I will.
That's before the product's released?
Separate issue. Before the product's released. This is all about the continuation. You have to file it before the patent office formally approves it. And it's like a chain. Okay, you file your first application, this will be A. You get a patent on this. Before it issues as a patent, you can file a continuation. It has the same technical description. You're not really changing anything except for the claims at the end. You may have a device in application A, you may have a method in B, you may have a strange system claim in C.
But this is before the official filing date or the official effective date?
Before the patent issues,
Okay.
the first patent. Yep.
So you can basically keep the application open indefinitely? by
Yes.
doing this?
Yes.
And keep adding on claims?
But you can't sue.
You can't change the subject matter. All right? You can't add new things.
I thought you just said you could add another claim.
You can add claims, but you remember your claims are the scope of your invention. If I describe an invention as a device, but there's a method of operation, I can claim a method in a continuation. That's not adding new because it should be described in the patent application originally. So let's say your device has A, B, and C elements. Each continuation will claim some variation of A, B, and C. You can't add D, and because that would be new matter, we would say. All right. Let me explain why this is important. You file your patent application, it issues as a patent on January 2nd, 2018. You have a patent that covers your product. That's great. You don't file a continuation because you want to save money and you don't have the resources to do it. 2 years later, this is what will happen. It will happen. A competitor introduces a competing product that copies almost everything, at least all of your essentials features. The competing product avoids the patent claims somehow. Every claim can be designed around. Okay, you just have to find the way to do it. What do? Well, you're really kind of stuck from a patent perspective there. This next example, same thing, issue patent covers your product, you choose to file a continuation. Now, 2 years later, you have a competitor out there that's copied the essential features of your claims. But now you have something pending. You can draft claims based on the original disclosure that possibly covers the competing product. That's a very different position down the road than if you were in the first example. So think about them. Continuations are important. Let me get through this a bit. Cost of enforcement. Okay, if more than $25 million is at stake, that's $2.5 million to do it. That's both sides are going to pay that. This is from 2017. Patent litigation is expensive. It's expensive to enforce, but recognize everybody is looking at that the same way. Okay. Often this is a driver for negotiation and licensing. Patent infringement, again, you make, use, or sell what is claimed. And we'll get into a very quick example of what that means, I think is helpful for you. A claim, say it's A, B, C, and E. All right. Product A has A, B, C, D, E, F. Product A infringes claim 1, even though it has this extra feature, F and D. That makes sense so far? Product B has A, B, C, D and F. It doesn't have E, which is required in the claim. Product B doesn't infringe the claim. It's not, that's the analysis, that you would do. Yep.
Would product B be able to make a patent with claim 1 being A, B, C, D, and F?
Entirely possible. So it depends on, a number of things. If you're in the chemical space, you need some unexpected result. If your device is a bit more mechanical, then you're looking at a pretty focused claim, but it's possible. I want to get to, I'm going to have to skip ahead a bit. 2 issues that come up. Can you get a patent for it? And then do you have freedom to operate? Is there something else out there that you need to be concerned about? So there are 2 separate issues. Patentability is all about, can we get a patent? We've talked a lot about that. Freedom to operate is focused solely on what you're going to sell. It's very commercially focused. You take this product and you compare it to whatever patents that might be out there that are relevant and make a determination if you infringe or if you don't. And we won't go through all of this flow chart, but you'll see this. Go back and look at it. If you have questions about it, please ask. But this is the analysis that I would go through in a freedom to operate study. So you got to search for patents, find which ones are relevant, do a little deep dive into it, and then keep going further as you see fit. Why do you do this? Well, there's legal reasons, but there's business reasons. You want to know if you infringe a patent or not. I mean, that's one way to guide your development path. Just questions you need to do. A legal tool to limit damages. If you do find yourself sued and you do find yourself being held liable for patent infringement and the patent's valid, this opinion that you could do will help limit those damages. You submit it to the court. Investors, they want freedom to operate. This is a big part of what I do for some of my clients is I'll get asked by a venture firm, do the patents cover the product, and what is their freedom to operate position? They don't want to buy a patent infringement lawsuit. Basically, don't want to invest in that. So something to think about. Licensing, I'll skip through this. We're going to dig into that a lot in our next series, but let me just go through an example real quick. I'm going to read this, and then we'll see how all this plays out. New code develops a health monitor with a new sensor that can obtain physiological characteristics. It far exceeds data. I'll skip down a bit. The new device does the work of 3 different devices and results in far superior data sets. Marketing calls it new device. The device has an ergonomic shape with sleek design features. Developing the new device used a new coding scheme, not just software. You created new code to do this. The new coding scheme can create software used to operate the sensor module. It includes, you use open source software as you're doing this, okay? The software uses a compilation of physiological data obtained by new code over the last 20 years that others don't generally have. All right, so let's just overlay what we've learned on this. So trademarks, okay, that's kind of an easy one. New code, new device, those are the subject of trademark protection. Copyrights. Maybe the ergonomic shape, that's pushing the envelope a little bit. Certainly the parts of the coding scheme, the software, open source software is open source because they recognize you can license and permit use of it, okay? So there is some copyright features there. Patents. Okay, what can you patent in this thing? The health monitor, the sensors, possibly the increased data transfer rates. That's a little bit, questionable. The new coding scheme, maybe software. Those 3 areas, you're brushing up on this patent eligibility issue that we spoke about. Okay. And then trade secrets. So maybe your software code is the trade secret. The data. The physiological data, software. So I ran through this example quick, but I wanted to get to this result. You can see one product. This is your IP strategy and all the things that go into what goes into protecting something. Okay, it's not one isolated thing, and it should be all-encompassing as much as possible. Now, a couple of things will just, I'll read these questions, okay? You hired an independent contractor to write software but never put anything in writing, all right? You hired a consultant that helps you conceive of the product. You don't have any agreements concerning inventions in place. What happens to the IP? All right. Your brother-in-law is a graphic designer and created your logo. A few years later, there was a bitter divorce and he never had anything in writing about the logo. What happens? Probably can't go talk to your brother-in-law. All 4 issues above you're working through, then comes a mammoth due diligence request from a venture fund, heavily focused on IP. All right, part 2, we'll go into all of that. Okay? I rushed at the end, but thank you for your time. That's all I've got for today, and I'm around and appreciate it.